In all cases where a person refuses to comply with a roadside test demand, whether it's FST, saliva, or roadside breathalyzer tests, there is something in law known as a reasonable excuse. If your refusal to comply is predicated on a reasonable excuse, for example, you couldn't perform the SFST tests because you had a broken femur, or you couldn't perform the roadside breathalyzer test because you suffer from COPD and despite your best efforts, you were unable to produce sufficient air for the sample, then you may be excused in law from refusing to comply. The difficulty is that it's often not possible to determine whether or not you actually have a reasonable excuse in the moment. If your excuse is a legal excuse, such as the validity of the demand or whether or not the officer did or didn't have a reasonable suspicion to make the demand, that's not often something you can determine because the information isn't available to you at the roadside. If your excuse is physical in nature, like a medical condition, a breathing problem, or some type of illness or injury, then it's often difficult to say, I said I wouldn't do it without trying, and to be believed on that basis. And so people who are facing demands for compliance with roadside breathalyzers, field sobriety tests, or saliva tests are often in a difficult position between a rock and a hard place if they have something that would legitimately prevent them from being able to participate in the test. If they say no, they'll be charged with refusal. If they participate and they're unable to do it, they'll also suffer charges.